The Honorables, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court.
Good morning, everyone, and welcome to this remote oral argument session of the North Carolina Court of Appeals. I'm Richard Dietz, and I'm joined on the panel today by my colleagues, Judge Valerie Zachary and Judge Jefferson Griffin. We have one case on the calendar for oral argument this morning, and that's number 2088, Carolina Roofing versus Eily. And we've confirmed the parties are ready to proceed, so we'll hear from the appellant.
Thank you, Your Honor. I would like to reserve 5 minutes for rebuttal. May it please the court, I'm Chuck Kitchen. I'm representing the appellant, Kiara Eily. I want to first address an order from the court that was issued last week regarding the timeliness of this appeal. As the court probably has realized, this case was, the notice of appeal in this case was filed 1 business day late. This appears to be due to the fact that it was served 5 days after entry of the order. However, when you take out Saturday and Sunday, it was within the 3 days, which rendered the time for filing the appeal 5 days earlier. Because of this being filed late, I have filed a petition for a writ of certiorari last week, and I also referenced the case of In Re SZH in my writ of certiorari, in which the court granted cert when essentially the same thing happened, where you had a weekend intervening between the time of entry and the time of the notice of appeal, which affected the 30 days running, and it was also filed 1 day late. On the basis of that case and basis of excusable neglect, I would ask that the court grant the petition for a writ of certiorari and allow the appeal to be decided on its merits. This case is a case involving discovery in a dispute involving roofing. There are 2 main issues in the case. The first involves 56 photos that were taken by counsel and are argued to be protected by the attorney work product immunity. While the appellee's brief states that the photos were taken during a joint inspection of the property, the inspection was actually from a request for entry upon land and inspection, which was served by the appellee. This is included on page 70 of the record of appeal. On appeal, several of the photos were taken while the counsel and his individuals were there looking at the property. However, several of the photos were also taken after they had already left. The purpose of taking these photos came about because counsel for the appellant could not be present at the inspection. She asked that I be present and take photos and explain to her what had happened and what my general impression was of what the merits of the case were based on what I had seen. These photos, to a large extent, represent my mental processes and what I thought was important in the case. As such, pursuant to Rule 26B3 of the Rules of Civil Procedure, I would submit to the court, and based also on Boyce and Isley versus Cooper, that since these represent mental impressions of counsel, they are simply not discoverable under any circumstances.
So the explanation that you just gave of what the purpose of the photos were and why they exist, did trial counsel tell that to the trial court at the hearing?
Trial court explained that these were taken by counsel. I don't think she got into as much detail as I just explained. I think she did, I believe she did say to the trial court that she had me appear for her and that she had not taken the photos, but that I had taken them and that they remain on my cell phone. And I've gone over them with her from the cell phone.
Because I think the argument we're going to hear for your friend, for the appellee, is that the trial court was waiting to hear an argument that this is protected by the work product exception this is the reason that these photos contain the mental impressions of my law partner that's intended for me. So this is sort of the core part of work product. And so that's why they're listed in the privilege log and why we don't have to produce them. But that never happened. And so the trial court made this finding that there was no evidence or argument about those. And that's why the motion to compel was allowed with respect to those photos. So what's your response to that? I think we're going to hear that argument in a moment.
My response to it is, first of all, she did go over the fact that it was done by counsel, and it was on the telephone that this was not something produced by a third party. And by definition, I would say that if you have attorneys taking the photographs for their use, not for the use of anyone else, that is attorney work product. It is the impression of the attorney because the attorney selects which photos to take. It simply isn't a random act. The other side doesn't see all the photos being taken. If they did, to a large extent, it wouldn't matter because they know what you're looking at. They did not do so in this case. Because of that, because it is a situation where the attorney is actively looking through, in effect, if these were documents, it would be looking through documents. In this case, it's looking over a roof and looking to see what the problems with the roof are. That was presented. And because of that, I would say that clearly has to be mental impressions. If it is anything, I don't know what else it would be. And because of that, I would submit they are not discoverable. If that answers your question, I'll proceed to the next issue. Then the second major issue I believe that's involved here are expert witness disclosures. These are divided, or I will divide them into two different parts. When you have expert witnesses, you either retain the expert to help you with trial preparation, or you retain the expert to actually testify in court. There were 5 interrogatories and 6 requests for production in which there were objections as to the information requested based on it being held by an expert witness. The appellant did receive documents that were from experts who were retained solely for trial preparation. They were not included in the discovery given to the appellee. Pursuant to Rule 26B4B2, those documents we would submit are not discoverable. And they can only be had for discovery for physicians, which is not relevant here, or a showing of exceptional circumstances. As for expert witnesses who testify, first of all, there was a second set of discovery that does not appear in the record, and I do not believe was in front of the trial court, although I could be wrong about that. Obviously, I was not present and not entirely clear about how that happened. But in the second set of discovery, the expert witness was identified. So I'm not sure if the appellee still has any argument as to that. There was not any in the brief, so I'm not clear if they're actually still wanting any further information. The way the appellate rules, or the rules of procedure rather, are set up is once you identify that expert witness, then and give the summary of what they're going to testify to, then the parties can obviously depose the witness and get a full explanation of what his opinions are. That has not happened at this time. It may happen subsequent to this appeal.
So I think we're also going to hear another argument from your friend for the appellee here, which is that this isn't a privilege or work product argument, what you're making now. And since we don't have, what might be thought of as pendant appellate jurisdiction, we can only hear the issues where there's a right to an interlocutory appeal. And this is just a sort of routine discovery dispute, a disagreement about whether certain documents should be produced or not, and those don't get immediately appealed. So what's your response to that?
My response to that is, first of all, as to the second argument that was made by the appellant, I think his argument may be sound. as far as not complying with the rules and the procedural issues. I would not, I cannot argue that that really affects a substantial right. However, with expert witnesses, I submit to the court that it does affect a substantial right because, in accordance with the case of Islam versus Bank of America, which is cited in the brief, if you have a right which will be lost, if it's not reviewable by the appellate court, then it affects a substantial right. It is one of those things that these expert disclosures, if they're given to the other side, they're simply lost. They're no longer secret, they're no longer privileged, they're no longer anything. And the rule specifically says they are not discoverable if it is for an expert that was not retained to testify. And I believe that's all we're talking about here. The other information, the appellee already has, so that would be the only thing that would be presented that's not already been presented. That particular privilege or the particular right under the statute not to disclose, I will submit to the court, does affect a substantial right. If you have to disclose that, it is gone. You cannot cure that later on, and it's something that can adversely affect your case depending on what's present in that particular expert's opinion. Plus, it tells the other side to a large extent where you may be going in your case. It discloses your trial tactics because you've asked them, okay, you're the expert, tell me if I argue X, is that something that can be argued in this case? And they'll come back and say, here's where I think the issues are, or they may say, here's what we have found that are the problems. So you're going to be arguing that. So it really discloses your trial tactics. It cannot be reversed once it's done. And the statute simply says it's not discoverable for good reason. And I will submit to the court that it does affect substantial right, and while it is interlocutory, it is immediately appealable.
I mean, I find that a persuasive argument. There's a lot of case law talking about a substantial right being involved when you can't unring the bell, essentially. So disclosure of confidential information and things like that. One challenge you have that I think we're going to hear from your friend for the appellee is that's the persuasive argument you made just now is not the one made in the opening brief in the statement of grounds for appellate review. There's just one categorical statement there, which is that you can, when you're dealing with work product, those are immediately appealable, like attorney-client privilege. And so, what's your response to the argument that it's too late now to try to build the substantial right argument that you just made?
I believe it's in the brief, Your Honor. On page 7 of the brief, it talks about that an appeal lies to the Court of Appeal from any interlocutory order or superior court that affects a substantial right. It discusses the case, the Bank of America case after that, and quotes it, and quotes what I've just said to the court. So
I thought that case was dealing with attorney-client privilege and work product.
It does, Your Honor, but I think that is the same. I believe that's good law as far as anything that any particular issue that affects a substantial right. I don't believe it's any different than the particular issue of the experts. I believe it's the same law. And I will submit that while obviously I would, since I'm arguing today, and I hadn't written the brief, I would like to have a little more in the brief. I think it does touch on it and covers the particular argument. And I will submit to the court these, to a large extent, what's being argued today is not new law. As the court just noted, there are quite a few cases out there on discovery. And I will say that the expert witnesses are covered by the rules of civil procedure. I would ask that the court follow that and not require it to be disclosed. As for any remaining issues, I will reserve the remainder of my time, and I will stand on my brief And I will simply ask that the order of the trial court be reversed as to these two issues. Thank you.
All right, thank you, counsel. We'll hear from the appellee.
Good morning, Your Honor. Thank you, Nelson Harris, for the plaintiff appellee in connection with this case. With respect to the initial issue, it does appear that defendant's notice of appeal was late, which would normally leave the Court of Appeals with no jurisdiction to consider the appeal. Your Honor, it's somewhat ironic that the notice of appeal was late, given that the defendants had filed a motion to stay the effectiveness of the order and secured a stay order pending appeal before the order was entered or before a notice of appeal was filed. At least there was some notice of defendant's counsel as to what was coming. Your Honors, the court could certainly treat her appeal as a petition for a writ of cert, or could grant the written petition that was recently filed by the defendant. However, the plaintiff would hope that the court would choose not to do so. Your Honor, this isn't a case like SZH, where the issue involved was a termination of parental rights of a non-custodial spouse and father. This is a case of a mostly interlocutory appeal of discovery issues. So the Court of Appeals has the ability to deny the petition for the writ, and it should exercise some discretion when it considers that. Otherwise, a late filed appeal would be followed by a writ petition for a writ in all cases. And I think that the Court of Appeals needs to decide whether or not the case is important enough to hear it in spite of the fact that it was not timely filed. Otherwise, that timeliness requirement will effectively disappear. This certainly would be a case that I would think would be on the low end of the scale for determining whether or not, low end of the balance in terms of determining whether or not the petition should be granted. Your Honor, with respect to the merits of the case, plaintiff would respectfully contend that the only part of the defendant's appeal that is not interlocutory is her condition that it was error to require the production of documents identified in her defendant's amended responses to plaintiff's first set of interrogatories and requests for production. The defendant produced a privilege log, but did not did not bring anything to tender to the court for in-camera review, did not really describe what it is that the pictures or the documents showed. And I would say that, if the Court of Appeals is going to consider the matter, it should be, this appeal, it should be for this purpose. I mean, it's quite common for attorneys to make sort of a blanket argument or a blanket objection to production of documents that are protected by the attorney-client privilege or the work product document. You'll have an interrogatory asking for identification of documents. They'll put in that objection, and then they'll put in, subject to that objection, we're identifying these documents and producing them. You really have no idea what it is that is being withheld from production, even if they do, as the defendant did in this case, sort of give a privilege log with a general description. You really have no ability to say, hey, this is something that should not be covered by the privilege, and you don't have the ability to get the court to look at the documents, I'm not saying that I should be able to look at the documents, but I should be able to have the court look at the documents to say whether or not they're privileged.
Well, the argument, as I understand it, that your friend for the appellant is making is that if during litigation the parties had taken inspection of some premises, and the lawyer for one of the parties is furiously scribbling in a notebook notes as the lawyer's looking around, that nobody would seriously argue that because anyone could have observed the things that the lawyer was writing down, that those don't have any work product protection. And so your friend for the appellant is saying the reason that's so axiomatic is that the mental impressions necessarily are there. And if you're taking a photograph instead of taking notes about what you're seeing, the same is true. So, the argument is we didn't have any obligation to do anything more than inform the court that these were photographs taken by a lawyer after the litigation had already commenced, and that's enough. So what's your response to that?
Your Honor, it's hard for me to know what the photograph. If counsel was taking notes and identified notes as taken during the course of the inspection, I certainly would not contend that the court even needed to look at them. In terms of the pictures, it would seem to me that the burden's on you to show that they are covered by the attorney-client privilege or the work product doctrine, and you can't simply do that by saying, they're covered, which is effectively what they did here. I mean, this discussion about mental impressions, I took these after they were gone, none of that was part of the record. I mean, if you want the court to uphold a claim of privilege, you need to do something more than simply say that I have documents that are privileged. I mean, I think that would be my fundamental argument on that particular issue. You have to do more than simply say I have privileged documents. You need to say something about why they're privileged. And if there might be a dispute, then you need to have them available for in-camera review. There just needs to be a standard there. And that's, I think, why the trial court found that defendant presented no evidence that documents identified in the privilege log were protected by the attorney-client privilege and work product doctrines. It's sort of a recognition that you've got to do a little bit more. And I think the question for the Court of Appeals is, was that an abuse of the trial court's discretion? And I would strenuously argue not, that the trial court properly determined that more was required, and that's why they, ordered that production.
Let me ask you about that finding by the trial court. So it seems like one of the key legal issues here is whether, at least on the merits, is if you say in a privilege log, this is a photograph taken by a lawyer after the litigation commenced, is that enough to create the work product privilege, or does there need to be some evidence or argument presented to the court on the motion to compel in order to preserve that? And so I guess what I'm asking is, was the trial court, was that finding that there was no evidence presented, was that a finding there was no argument and so it's waived, or was it there's no evidence that this was work product? Because as I said before, your friend for the appellant is saying it's axiomatic that if we say we took a picture, our lawyer took a picture after the argument or after the litigation started, that it's work product. And now the burden has shifted to the party requesting that document to show that there's some reason to overcome that work product protection. So what's your response to that?
Well, my response be to that argument? I would still think, that there would need to be a little bit more about what pictures were taken. I mean, I heard Mr. Kitchen's argument. Some of those pictures were taken when it wasn't part of the group going around and taking pictures. I would say that, well, that's certainly something that, it's a better argument for privilege than simply these were pictures that we were all taking while we were walking around, and might even have included pictures of the people who were, like me, who were there too. Um, I guess fundamentally my argument would be that the burden doesn't shift in the way that the Court of Appeal that you suggest, that the burdens on them to do more than simply say it's privilege. They need to say, here it is, and it's privileged because. At the very least, that's the best argument I've got. And with respect to the remainder of the appeal, Your Honor, I would simply rely on my brief. I think most of the rest of it appears to be, except for the claims of privilege, with respect to the documents and privilege log, it's all interlocutory. It's just a normal discovery dispute, and that even if there were something else in there, they couldn't show that the trial judge abused its discretion.
All right, thank you, counsel. I think we understand your argument.
Thank you.
Any rebuttal?
First of all, as to the notice of appeal and the argument that everybody will, be filing things late, that simply isn't what happened here, and I'll submit that's not likely to occur. First of all, both parties believe that the appeal was timely. The appellate in his brief stated that the appeal was timely. This is simply a situation which does occur, and I'm not sure what frequency, because of the 3-day rule, and you do not count weekends. If you do not look at a calendar when you're looking at when you're required to file your notice of appeal, it is very easy to say, oh, this was filed beyond the 3 days, therefore I have 30 days from the date of service. I would hope at some point that rule gets changed or somehow modified, because it is a trap. And it appears just from looking at some of the opinions from this court that a lot of attorneys have a tendency to step into it. The other issue I would like to address is the in-camera review. First of all, in this situation, there was no order by the court. The court didn't say, I would like to see the photograph. And secondly, I don't believe that it would have helped anything for the court to see the photographs. These are pictures of roof and walls. It's simply, there's a dispute about roofing. You're taking pictures regarding that dispute. I'm not sure, what is the court going to be looking at? Well, we're looking at a roof. That really doesn't tell you anything about whether or not they can be privileged. And in this case, the court was told the photographs were taken by counsel. It's on counsel's telephone. These were not taken by the party. This was part of our preparation for court, and as such, I will submit that they are privileged. I believe the court erred in saying that they were not.
So the argument we heard from the appellee is you have to at least provide to the court some argument and supporting evidence for why the work product protection would apply. And I think if I understand the argument, it's that just never happened at the hearing because, for example, trial counsel never said, these are the mental impressions of my law partner who took these photographs. And without that, the trial court's finding that there was no evidence presented, essentially there was no argument to justify the protection, and therefore the court was correct to say you must produce the documents. So what's your response to that?
My response is I don't believe there are any magic words. Just because you don't say mental impression does not mean that they are then discoverable. Counsel did say they were taken back by an attorney, not her. Counsel did say they're on the attorney's telephone, and the attorney said they were taken during the course of discovery. As such, I believe that puts the court on sufficient notice and asks the court to protect those, because under the rules, they simply don't come in. They are work product. I mean, I don't know, otherwise your put back in the old code pleadings almost, where you had to say, here are magic words that you must use, and if you do not use these words, you will lose. We've gone beyond that, I believe, in our jurisprudence, in which case you don't have to use magic words. You have to say what happened, which was done at the trial court, and then the law should be applied to that. And I believe that was done in this case. And for that reason, I believe that the court was in error. If there's no other questions from the court.
I have a question. So are you saying then that basically you don't have to have it available for in-camera review to meet your burden when you're alleging that it's work product?
I believe that you should have it available as a general rule. And if it's not available, if the court asks for it, you must be able to produce it to the court. Obviously, when you produce things to the court, normally they're put in an envelope. They're put under seal and given to the court. So what did not happen in this case, and the court didn't ask that it happen. Had the court said, I want to see the photographs, you are to produce them, then obviously the counsel would have to produce them. But also in this particular situation, I don't see any reason why the court would ask to see them. I mean, they're photographs about a roofing dispute. I don't think it tells the court anything. It's not like a document which you can read and say, oh yeah, I see where they're going on this. One of the issues in the case is about whether or not there should have been a diverter and did that do anything. Well, if there's a picture of a diverter, does that tell the court anything? Well, no, it doesn't say anything. And I will submit to this court that that's probably the reason the Superior Court judge didn't ask for it, because it wouldn't tell him anything. If that's all the questions from the court, then I will stand on our brief and ask that our appeal be granted and that the order of the trial court as to those two issues be reversed. Thank you.
All right, thank you both for your arguments, and we appreciate your willingness to appear in this remote proceeding. We'll adjourn. Mr. Soar?
Yes, Your Honor. This session of the North Carolina Court of Appeals is now adjourned.
All right, thank you both.
Thank
You're free
you.
to drop off now, but we appreciate it. Thank you.
Thank you. It was it's interesting. It was an interesting experience to do this remotely.
It is. This one went off without a hitch, so thank you both.